from testing results seems to be changing rapidly. We know that the time of onset of symptoms following contraction of the virus is now being seen sometime 2 to 14 days after exposure. So that gives a pretty wide range for when a person could have contracted this virus based on when the symptoms begin. In addition, many people who are testing positive are not exhibiting any symptoms at all, which further complicates the issue of who has it and where did someone get it. In addition, we don't know exactly how long someone can be contagious who has it. I've seen estimates up to 21 days with or without symptoms. So proving that you caught it from a particular person at a particular time is going to be extremely difficult given the inability to pinpoint something like an accident and say, I fell and I hurt on this day. Well, how do you prove when you contracted an invisible virus? So perhaps in acknowledgement of those difficulties, Louisiana, like many states, has proposed a new law which would address workers' compensation coverage for COVID-19 cases. And Chase is going to attempt to share a copy of the bill with everyone on here that you can download. But I'm going to go over some of the highlights with you. This is not yet a law. This has not been discussed yet in the legislature. But this is, it appears to be the direction that the state is going, and other states are following suit with similar bills that are being proposed. So the first section says that every essential worker who is disabled because of COVID-19 shall be entitled to compensation provided in this chapter, just as if the essential worker had received a personal injury by accident arising out of and in the course and scope of his employment. The language of this section is extremely problematic. What I anticipate they were trying to do was to forego the requirement for an accident, given that it's going to be difficult to prove when you contracted something that is invisible. By doing that, they have overextended the protections given to essential workers by saying that anyone who is an essential worker who contracts COVID-19 is entitled to workers' compensation. This is beyond a presumption of causation. This is saying that you get it no matter what if you're an essential worker and you are diagnosed with this disease. The second concerning aspect and confusing aspect of the proposed bill is the definition of an essential worker, which says that it is persons working in public safety, government, disaster response or healthcare, or private business as designated and deemed necessary or critical for response to the COVID-19 pandemic by their employer or by virtue of their official commission. So an essential worker under this definition would be anyone who is listed in the governor's definition, which includes essential infrastructure, charitable and social services, hardware and supply stores, critical trades such as plumbing, electricity, essential business operations supplies, residential facilities and shelters, manufacture, distribution, and supply chain for critical products and industries, and hotels and motels. In addition, this provides that essential workers are those deemed necessary by their employer. What we think this means is that if an employer tells someone they have to come into work, they would be covered under this if they contract COVID-19. The Act also lays out the timelines for filing a claim. Claims for disability will be filed within 1 year of the date that, 1, the disease manifested itself, 2, the worker is disabled from working. It does not have an or an and on this part of the statute, so that would need to be clarified in the legislative process. Claims for death would be filed within 1 year of the date of death or when the claimant has reasonable grounds to believe that the death resulted from COVID-19. This would be an employee's exclusive remedy, just as any other workers' compensation claim. The only defense which is listed in the statute, is if the employee willfully and falsely represented himself as not having previously suffered from COVID-19 when he was hired. So essentially, if you lied about it and at the time of your hire and you had had it before then, that's the only way for an essential worker to not be entitled to benefits for contracting COVID-19. Again, this is not a law yet, but this will give you some insight into where the legislature is headed with respect to workers' compensation for essential employees. In the interim, there is, without this bill being passed, the employee bears the burden of proof by a preponderance of the evidence that they contracted COVID-19 while in the course and scope of their employment. This can be done in one of two ways, either as an occupational disease or as an accident. In the course materials that we've circulated beforehand, it goes into detail about the analysis under an occupational disease. That is one that is characteristic of and peculiar to a particular trade. This would likely apply to individuals who are working in healthcare, particularly those in critical care, working in COVID-19 units, or being exposed to patients that are coming in with COVID-19. We think it would also apply to people who are interacting with the general public on a regular basis as part of their essential duties as an essential employee. For any others, it would likely not apply to them. And for those individuals, for non-essential employees, they would likely have to prove that they contracted it by way of accident. And to refresh everyone, an accident is defined as an unexpected or unforeseen, actual, identifiable, precipitous event happening suddenly or violently with or without human fault and directly producing at the time objective findings of an injury, which is more than simply a gradual deterioration or progressive degeneration. Now, the two problems with proving an accident by contracting COVID-19 is one, how do you prove the actual identifiable event in which you contracted the disease? The second would be the requirement that it directly produces at the time objective findings of an injury. As we talked about earlier, it takes anywhere from 2 to 14 days, possibly longer, for symptoms to onset after someone contracts the virus. So in looking at the way that courts have applied these requirements to other physical injuries, I think we can see that it is possible that someone contracting COVID-19 on the job would be classified as an accident. Think about cases where someone is performing strenuous activities at work and they have a particularly strenuous job that they perform over 3 days. A week later, their back starts hurting. They go to the doctor, they say, I don't know what I did. I know I worked on this particularly heavy job at work for over 3 days. I didn't do anything else at home. I didn't do anything else at work. A few days later, my back started hurting significantly. Well, medical causation, doctors will often link that if there is no other potential cause. And the courts, in our experience, and according to the published cases, will allow for that cumulative trauma or longer period of exertion to qualify as an accident. Even if they don't know exactly the moment when they did it, they know generally when it happened, and the court will say that that's sufficient for an accident. So for situations like that, that would not fall within the occupational disease section, we think that if someone is able to say, I was exposed to someone on this day or in this general period, I didn't do anything else outside of work, they could potentially meet the definition of an accident. When is COVID-19 going to be compensable, and how do we investigate it? The simple, well, based on our discussions with people in the legal field and the general public perception of what's going on right now and the way essential employees are being treated, we anticipate that the courts are going to liberally construe the accident or occupational disease requirement in favor of coverage for the employee, particularly for essential employees such as healthcare workers and people working in the food industry, people who are out there on the front lines, generally interacting with the public and treating those who have been infected. For non-essential employees, even if the bill passes in some form, they would be excluded from that. So they would have to prove an accident or occupational injury in accordance with their usual preponderance of the evidence, burden of proof, as we discussed earlier. The cases which we think would probably be compensable are ones based on what we know so far about the virus, clusters of positive employees at work, instances of identifiable exposure with a confirmed positive while in the course and scope of their employment. And in such cases, we've laid out in our materials some questions that we think would be beneficial to investigate when somebody contracted a disease and whether it is work-related. Going through those, was there any confirmed exposure with someone who tested positive at work? That should be a threshold question for any new COVID-19 case that comes in. If so, you need to know the dates of the exposure and the extent of the contact with the individual. Were you wearing any protective equipment at the time? The next question would then be, when did you first start having symptoms? If we know now that it's between 2 and 14 days, that'll give you a timeline for when they could have potentially been exposed. We anticipate that these things are going to change as we get more information and more test results come in. So it will be good now to ask the questions to get as much information as we can to be able to evaluate compensability as our knowledge of the virus changes. We had initially put some stuff in there about Mardi Gras. Most cases that you're going to get now are too far extended from that time period for anyone to have contracted it and just now be showing symptoms. But if you have some old cases and someone lives in South Louisiana, definitely ask if they attended any Mardi Gras parades. It appears that that was when the virus really began spreading in earnest in Louisiana, which would obviously go against causation and contracting it in the course and scope of their employment. Travel, where have they been, by what method? And now we can tailor questions really to within 2 or 3 weeks before when symptoms began to manifest. Have you taken any precautions outside of work and at work in order to prevent yourself from contracting the virus? Are you wearing masks? Are you using gloves? Are you washing your hands regularly? Were you avoiding crowds? Have you been to any large gatherings in the last 3 weeks? These are all going to be taken on a case-by-case basis. And in order to evaluate whether it's more probable than not that someone contracted it at work, you need to get as much information as you can about what they've done both at work and outside of work to determine if it happened at work or not. We've been also asked questions about what kind of doctors are we going to be able to use to establish causation. Right now, pulmonologists and critical care doctors appear to be the ones that are most adept and trained at offering an opinion on causation. But again, it's going to be difficult now without confirmed documented exposure in the work environment to prove whether you contracted it at work or outside of work, given the lack of knowledge about who's contagious, people not having symptoms and not even knowing that they have the virus and spreading it. So, it's important to ask all the questions to get as much information as you can to be prepared as we start learning more about the virus. Again, at this point, the essential workers that we discussed earlier, those cases are probably going to be found compensable. If not a legislative presumption, there's going to be a strong inclination from a policy perspective that we anticipate the courts are going to implement to find coverage in favor of those employees. There are also some potential methods that will be available later in an effort to determine causation. I think we're maybe a month or so out from this, but I know Google and Apple are pairing for some contract tracing software to be put into phones where essentially everybody who logs in or opts in, their phones will ping and they will keep that data for 14 days. And anybody that you come within 15 feet of will be pinged with you. And if someone tests positive, they then notify through the app, and a mass message is sent out to everybody that's been pinged in the last 14 days to say that you've been within 15 feet of someone who has tested positive of the virus. We're a little ways off from that. That's something that could help down the line for causation. As of now, we're keeping an eye on what the legislature is doing. We anticipate that there's going to be some form of presumption in favor of essential employees. Hopefully it is not as broad as what is currently written. For now, handle your cases as if there is or under the current requirements that an employee prove by a preponderance of the evidence that they contracted an occupational disease or sustained an accident while in the course and scope of their employment. Again, any questions that come up throughout this, make sure you write them, and Chase will circulate those to us a little later. I think Jonathan is up next with a discussion about liability for accidents while working from home.
All right, thanks, Josh. Today I'm going to discuss a little bit about injuries that occur while working from home, or for the telecommuters. We've been getting a good bit of questions regarding potential injuries that occur at the house, given that the COVID-19 pandemic has forced the majority, if not everybody, to be working from their house. It's kind of an unprecedented event. There's been similar instances, at least in South Louisiana, following Hurricane Katrina, when stuff was closed and employees were forced to work from home. And other situations, well, not similar to Louisiana, but like snow days for some states up north that, again, cause mandated work closures or force telecommuters to work from home. We anticipate that Louisiana is going to follow what most states have done when assessing the compensability of injuries that occur at home, that they're going to treat the home as a employer's premise. And they're going to look at the same things that we look at for an injury that occurs at the workplace. They're going to say, did the accident arise out of and in the course and scope of employment? Same test, like I said, they use if an injury occurs at work. They're going to be very fact specific. As we know, course of employment refers to time and place, whereas the scope of employment kind of refers to the employment-related risk of the injury. It's used to concentrate attention upon the relationship between the risk and the employment in terms of time, space, and whether or not the employee was acting within his assigned duties in furtherance of his employee's objective. The arising out of element is used to concentrate the attention upon the character, source of the risk. Um, Both arising out of and during the course and scope of must be present for the worker to recover compensation. A strong showing of one of them may be sufficient to compensate for a relatively weak showing of the other, or vice versa. Unfortunately, a majority of courts have found that an employer's lack of control over the conditions of an employee's home-based work premises is irrelevant. When looking at the nature and the scope of the in-home accident and the compensability of it, some factors to look at are: does the employee have a designated home office? It would help to limit whether or not the employee was actually working from a specific premise that can be considered part of his employment, and did the accident actually occur in the home office of the designated area where he's working? If not, did the accident occur in a place where the employee could reasonably expect to be? Again, this is difficult given that the employee is working from home. Not everybody has a designated home office. Some people work from the kitchen, some people work from the sofa. I mean, it's one element that we can look at. Another big element in this: was the employee working a specific shift or certain hours during the day, i.e. like a 9 to 5, and did the accident occur during the normal work hours? And whether or not there's any way to monitor if the employee clocks in or out. Another thing courts look at is whether or not the accident occurred during a deviation from employment, and whether or not the employee deviated from his usual business activities, and whether or not this deviation was minor, whether or not the deviation was completely personal in nature. Most states acknowledge that minor deviations are normal. If you go to get a cup of coffee, most states have what they call the personal comfort doctrine, in which they rule that employees who are injured taking short breaks from work to seek personal comfort can be eligible for workers' compensation benefits. And they've applied this same standard to people working from home. Like I said, coffee breaks, getting up to get a snack. I was looking at one case where a lady fell down the stairs while she was walking to go get a cup of coffee. The fact that getting coffee wasn't technically related to her employment or in further of the employer's business was not enough to overcome that. She was still within the course of her scope of employment. Another active question to look at is: did the accident occur while the employee was engaged in an activity whose purpose was related to his employment, or was it a purely personal activity, such as picking up the kids, doing laundry, doing the dishes? Those would be more easy to overcome versus, like I said, the small breaks, getting a snack, getting a cup of coffee. For example, I guess one of the most common scenarios is that somebody gets up from their desk or from their computer to turn on a printer, get some printer paper, and trips over a wire, twists a knee, injures the back. Those kind of incidents would more likely than not be held compensable. In Oregon case, the court decided in favor of an employee who tripped over a dog while getting fabric samples out of her garage. She worked as a web designer and couldn't have everything for her job inside of the office. So they said the act of her going outside to her garage still fell within the course and scope and arose out of her employment and was found to be compensable. There's certain practices that can be implemented to, I guess, limit liability. And I understand that given where we are right now, that everybody has to work from home. Some of these aren't really practical and it'd be difficult to implement, but some employers have created certain policies that outline the employers' expectations for the employees who work from home. And they established certain guidelines for like a home office, again, to designate a spot where they'll be working, to help minimize safety hazards. But unfortunately, the fall that comes with telecommuting is that the worker's entire home can be viewed as the employer's premises, even though the employer doesn't have access or control of the area. That's what I'm saying. To curtail that issue, workers should be required to identify specific work areas to at least try to limit the liability for what's considered the employer's premises. And again, this one also isn't really extremely practical. It may not always be possible, but some employers conduct periodic checks of an employees' home offices to try to identify and eliminate potential hazards in that immediate area. And again, if possible, to have a set or fixed work hours, and even specific meal and rest periods for telecommuters can help establish whether or not an accident occurs in the course of employment. Another issue that sometimes arises is an employee who leaves the house during the workday and suffers an injury in that manner. The general rule is that when an accidents happen while going to or from work are generally not accepted as compensable. Under the Louisiana Workers Compensation Act, they call it the going and coming rule. In these situations, it's important to determine the nature and the purpose of the travel from the home office. That'll be critical in assessing compensability. There are several exceptions to the general going and coming rule. Some of the more relevant ones in this case is whether or not the employer pays for travel, or whether or not a company car is provided, or whether or not they reimburse for travel expenses. Another one that may occur is whether or not the employee was on a what they call a special mission, or whether the accident occurred when the employee was following orders. It doesn't matter if the work was not in the course and scope of the employee's job, so long as it was being performed under the order of the employer. Under those instances, the accident will still be considered compensable. So if a supervisor instructs an employee to do something and the employee is injured doing it, they'll likely be covered under the Louisiana Workers Compensation Act. I guess some of the good news, I guess, is if an accident does occur while an employee is working at home, his job duties at the time were likely sedentary in nature. They were more than likely working on the phone, working from a desk, working at a computer. So even if there is an accident that's determined to be compensable, the focus should be immediately shifted to whether or not the employee can turn to work. I understand in reality, this would be difficult, especially with accidents occurring at home. The employee's version of events is going to be difficult to disprove. There's not going to be any witnesses. There's not going to be any security footage. On top of that, the Louisiana Workers Compensation Act is already liberally construed in favor of the injured worker. So it's going to be difficult to rebut the employee's version of events. The most important aspect is, though, it's going to be to address his or her credibility. Therefore, we recommend that any kind of questionable accidents that occur at the home initially be denied pending further investigation. I recommend contacting the claimant immediately to get as much information as you can. All of these kinds of cases are going to be extremely fact specific, and there's going to be a lot of variations. Just find out exactly what they were doing when the accident occurred, because that's going to be the biggest step into trying to controvert whether or not the accident occurred. So at this time, I'm going to turn it over to Chad Evans, who's going to be discussing the impact of the Families First Coronavirus Response Act on employees, on employers, and workers' compensation claims.
All right, folks. I am going to address this as fast as I can because it looks like we're already at about 25 minutes left. I know there are a bunch of questions. So I'm going to try and knock this out as quick as I can, hitting the highlights, and then we'll get to some questions. So the interesting thing, which seems to be overlooked as a result of the Families First Act, it's, the full name is the Families First Coronavirus Response Act. It's also called the CARES Act. It is comprised of two acts. It's actually the Extended Paid Sick Leave Act and the Extended Family Medical Leave Act, and they pertain to two separate scenarios, but it applies to employers with 500 or fewer than 500 employees. That doesn't mean that this will never have any application to large businesses. What I'm reading is that there's lots of state level legislation that is in the works, and actually a proposal in Congress that would remove the 500 employee cap. That would obviously then encompass everyone. But for purposes of today, as we sit here today, the Families First Care Act applies only to employers with less than 500 employees. Those with more than that, take heed, listen to this, take note, because it may apply to you, and it may be useful for general safe practices as well. What the Families First Act says is that covered employers, who are those with less than 500 employees, they must, it's not can, it's must provide to all employees that are unable to telework. That's a big if there are accommodations made to allow for employees to telework, they cannot fall under either of these two criteria, either of these two categories. And that gets into a fact specific. If you allow employees to telework and then they say, well, I'm having to do homework with my second and fourth grader, so I can't get a full day in, then they could be entitled to a proportionate share of the benefits, but what would be taxed against them is their ability to telework. And what they're entitled to is 2 weeks of up to 80 hours. If it's somebody who regularly works in excess of 40 hours a week, they don't get more than 80 hours worth of work or worth of pay. 2 weeks of paid sick leave at the employee's regular rate of pay. That's up to $511 per day in a total, quick math, 10 days, $5,110. Where the employee is unable to work because the employee is quarantined pursuant to government order or advice of a healthcare provider, and or experiencing COVID-19 symptoms and seeking medical diagnosis. The second part of this applies to those that are unable to work because of the need to care for an individual subject to the quarantine pursuant to government order or advice of a healthcare provider, or care for a child whose school or child care provider is closed or unavailable due to COVID-19. That second category of folks get pay up to 2 weeks, up to $200 per day at 2/3 their regular rate. The difference is that first category of people are going to have entitlement potentially under the act because it is a work accident. The second category of people, those people who may have entitlement to Families First Act proceeds, are not going to have a work-related event even under the mandate as proposed in the legislation or proposed legislation that Josh talked about earlier. So the employer's obligation for paid sick leave ends when the employer has either paid the employee for the equivalent of 80 hours or where the employee is returned to work after utilizing the leave. The employee must be employed for 30 days and be unable to work due to one of those needs in order to qualify. The leave obligations placed upon employers by the act are in addition to and do not replace the paid leave owed to employees under the employer's pre-existing leave policies. So if someone's got 2 weeks of paid vacation left or two weeks of paid sick leave that they can utilize, this additional 2 weeks wouldn't kick in until after the expiration of that. It's in addition to, it does not replace. And again, employees who are able to telework do not qualify for paid sick leave or expanded family medical leave under the act. If the employer sends an employee home, furloughs an employee, or shuts down operations before the employee goes out on leave, before they request it and go out on leave, they do not have entitlement to the paid sick leave or expanded family or medical leave benefits. They may, however, and likely will be, entitled to unemployment benefits. So there's one or the other. When the rule of thumb here is if the leave is not requested and someone is furloughed or laid off, or their hours are cut back due to a lack of productivity or lack of available work, or because the company's closing down temporarily or permanently, before that request is made, the paid sick leave doesn't trigger. Unemployment would be available. As you all know, unemployment, when it's working in conjunction with workers' comp, is you get a week for week credit. It's not a dollar for dollar. No one can get workers' compensation benefits for any week in which they're getting unemployment benefits. Just for the sake of the employers that are on this call, any group health coverage is provided to the employees by the employer must be paid and continued through the sick leave or expanded family medical leave periods. If the employee was responsible for contributing to some portion of that premium, they're not relieved of that obligation. And then it talks, there's some insight which for this purposes isn't really as significant, but just like in the FMLA, there is an obligation by the employer to have the same job available for the employee when they return following leave. However, they're not protected from any sort of layoffs or anything like that that would have affected the position but for the leave. One category of folks that's interesting is those that are not affected but quarantined employees. I think this is going to be an area that's going to be developed through case law. Those that their leave will extend beyond the 2 week period, because if they're quarantined but not infected, then they're going to fall within for 2 weeks or less, and they're going to fall within the Families First Act 2 week period. And in all circumstances, they're going to receive at least as much, if not more, in most circumstances, to what they would receive under comp. So while theoretically that may be an issue, it's really going to pertain only to those who are quarantined in excess of the 2 week period of time, which seems to be beyond what's really kind of the standard protocol at this point. If that individual subsequently tests positive for the infection themselves, they would still ultimately have the burden of proof to establish, more probable than not, that the condition is a result of its employment, as Josh discussed previously. However, that proposed legislation could change that. Again, that's a mandate. It's not a presumption. It doesn't shift the burden to the employer to then establish that it could not have been caused by employment. What it says is that if you're employed and you test positive, you get benefits. End of inquiry. Essential employees, again, I know Josh touched on this, but I just want to let everybody know, essential employees, a lot of the folks, for those of you all that deal with healthcare workers, first responders, restaurant workers, grocery store employees, those folks very clearly fall within the essential employment or essential employees definition. If anyone is designated by an employer as having to come into work, they are considered essential by that employer and would qualify. The other issue becomes if you leave it up to the discretion of the employees, because you have, you're not going to have more than 10 people and you can maintain appropriate social distancing. Would those folks be considered to be essential? I think that's going to be a fact-by-fact inquiry or case-by-case inquiry based upon the facts. There was a question that was posed, and I'm just mentioning it because for the individual that posed it, talking about when the benefits would be owed. That's actually what I'm going to address here now. The first installment of compensation payable for temporary total disability under comp must be paid by the 14th day after there's knowledge of an injury. On that date, the entire first 2 weeks, because as we know, we have a 7-day waiting period, must then be paid. The Families First Act provides that covered employees are entitled to 2 weeks, no more than 80 hours of paid sick leave at the employee's regular rate of pay. Well, regular rate of pay is always going to be more than 2/3 of pay. So they're going to have a windfall by taking the Families First Act payment for the first 2 weeks, where the employee is unable to work because the employee is quarantined pursuant to government order or advice of a healthcare provider, or experiencing COVID-19 symptoms, or has a medical diagnosis. The Families First Act is going to pay for the first 2 weeks. Workers' comp will be able to take a credit for those weeks. There won't be any, because there won't be any wage loss that occurs. Should the work-related disability or off work persist beyond those 2 weeks, workers' compensation entitlement would then begin on day 15. The worker will not get both benefits paid at the same time. You're not going to get both workers' comp and workers' comp and the Families First Act unless you are one of these individuals that earns more than $511 per day. If you earn more than $511 per day, then you're not going to be made whole by the Families First Act. And at least according to the law, you would be entitled to the 2/3 of the difference between the Families First Act and your pre-accident wages. Regardless of whether or not the claim is work-related, the Families Act applies. Practically speaking, the one thing that's going to allow, in the cases of handling them, it's going to provide a 2-week window that you wouldn't otherwise have to really get the ducks in a row. If it's determined that the employee's exposure did not occur at work, and he or she is tested positive for COVID, or directed by a healthcare provider to quarantine, or directed by a healthcare provider for quarantine and seeking a diagnosis, then the employee will be potentially entitled to payment of benefits under the CARES Act, but not by workers' comp. That pertains to non-essential employees, and right now to all employees pending the passage of this law. So hopefully that addresses the question of the one I was asking about the timeline from when benefits are owed and when they're paid. First 2 weeks go to the Families First Act. Day 15 starts comp, assuming that it's related to work. CARES Act, Families First Act does not matter whether or not their exposure is work-related. Some of the developments that have occurred over the last few weeks is, as most of you know, the Louisiana courts and Office of Workers' Compensation is closed through April 30th, 2020 at this time. There has been no strong indication one way or the other whether or not that will be extended, at least on the Office of Workers' Compensation front. There's been some hint from some of the state courts that they're going to open up. They're going to attempt to open up early to mid-May. However, the New Orleans mayor's proclamation or press conference last week may impact that. As of now, there are procedures in place to obtain approvals of full and final settlements, whether they're represented or not. The unrepresented settlements process is a little more complicated. You've got to make sure that people, mainly the claimant is the one that's the difficult one, make sure they have access to a video internet accessible source so that they can get onto a Zoom call or the likes of that with the judge to get theirs approved. The full and final settlements of represented claimants are going through actually fairly smoothly right now. There's just an additional process that it needs to be faxed to a designated judge initially and then mailed in subsequently to the proper venue district. The state proclamation that came out the week before last, number 43 JBE 2020, suspends the setting of the IMEs by the Office of Workers' Compensation, the ability to obtain suspension of benefits for failure to attend an SMO or IME, and the ability to obtain a PDH regarding suspension or termination of benefits for failure to attend SMO or IME. This really takes some of the teeth out of our defenses, as you can see, particularly in this time where, the claimants really have the discretion whether or not they truly feel concerned about attending these appointments. They can use this as a tool to draw the process out. Josh talked about the proposed law. I'm not going to revisit that again. Just yesterday, Governor Edwards advised that as of April 27, 2020, physicians can proceed with non-emergency time-sensitive medical procedures as they deem safe and appropriate. While that would appear to be a very small step, it is a step, and it is the first step that we've had since the closing of over a month ago now. And, it would appear that the governor is gearing towards opening up sector by sector. That seems from the sources that we've conferred with. This is the first step. He'll continue to review the numbers and see where how much more aggressive he can get with opening up the economy. One thing to think about when you're adjusting these claims is in the bill proposal, or the proposal of the Senate bill that Josh talked about, and talked about the one defense being where someone conceals or misrepresents their prior diagnosis. Another interesting thing is from the second injury fund standpoint. Under the second injury fund statute, Louisiana Revised Statute 231378, there are presumed permanent conditions that are hindrances to employment that, as long as the employer can establish knowledge of them, they are presumed permanent, and they are presumed to be a hindrance to the employee's employment opportunities. And given these 5, would not have any issue establishing merger for the purposes of COVID. Diabetes, coronary disease, multiple sclerosis, Parkinson's, and COPD, or any other chronic respiratory issues or disease. If someone denies that on a second injury fund questionnaire, I think that we've got a strong argument for 1208.1 fraud. And if they admit them, it is almost a shoo-in to second injury fund relief. Now, given what we've seen thus far in these cases, and from what the media reports are, the COVID treatment does not appear to be something that lasts a lifetime. The symptoms don't appear to be something that lasts a lifetime. They seem to run their course within a few days to weeks, a month or two, and then those individuals, depending upon how aggressive their condition is, and usually that's dependent upon their comorbidities, will return to the status quo. So meeting the thresholds may be an issue with regard to the 104 weeks of indemnity and $25,000 of medical. Although if someone is an inpatient, meeting that $25,000 of medical may not take that long. Anyway, just food for thought. Keep that in the back of your mind. The last thing that I'll mention before we'll get into some questions are the doctors' potential to consider for evaluations. Primary care doctors, your family doctors, ACMED, and infectious disease specialists. That's an additional to the critical care and pulmonologist. Guys, at the end of the day, what it's going to be is diagnosis is going to be established. What we're going to need to do is establish causation, which is going to be very fact intensive. And I think the doctors that we may need to establish is talking about merger on the back end, and talking about when the condition has run its course. Because what I foresee is people getting this and then dragging out the disability for weeks and weeks. So with that, I'm going to look into some of these questions and pass this over to Chase, our moderator, and go from there. Thank you, everybody.
Hey guys, I didn't see any questions that we didn't really address in the chat already. Does anyone now have any questions they want to send by chat, or if you want to unmute yourself and ask them now? I'll give you a second to do that. All right, if you think of any questions between now and next week, just email John And if there's something you want to be discussed next week in particular, just email John too. Again, email John your state and your adjuster number if you're looking to get CE credit from this, and we will take that information and submit it for the approved states. Got a question, is this recorded? Yes, it is recorded, and we will post that try to do it on our website and on Facebook too. If you want to get it sent to you, just email John and we'll figure out how to do that too. And also, if you need the materials that John provided to a lot of people already, but if you didn't get those materials from John, also email him and he'll send those to you as well. I'm gonna turn it over to John.
Hey folks, this is sort of our trial run. So if you have suggestions of things we could do better or differently, let us know. Next week, we will have additional topics. I am open to suggestions. We have some that we're kicking around internally today. I think next time we will sort of outline the topics every Tuesday so that if there's anybody in particular any topic in particular you want to hear addressed or you don't, you can skip that Tuesday session. We are recording these. They will be posted for sure on the Facebook account. We are trying to figure out how to post it on the website. It will be there. And again, the continuing education credits, I will be submitting those for you. We've got most of them approved. Mississippi and Louisiana are still pending. The other states, I believe we have the certifications back. So please let me get the credits for you if you can. Again, I will need your state ID, whatever state you need credit for, and your number so that I can submit it. Appreciate everybody attending. And again, if you need the materials, email me and I will send them to you. And you guys take care and stay safe.